Well, good afternoon, everyone, and happy Easter to you all. Thank you for taking the time to join this webinar. This webinar was organized in anticipation of the first Tanzania ADR Week 2026. We have organized this together with the Judiciary of Tanzania, specifically the division which we all know of as the High Court Mediation Centre. Now, I'll give it about 2 minutes so that we can have a much more fuller room. Hopefully, everyone would have been able to take some time off to hear a bit more about domain disputes in Tanzania. I will give it 2 minutes to allow for the traffic to come in. Thank you. We are 2 minutes past the 3 o'clock hour. My name is Madeline Kimei. Thank you for joining this webinar today. Again, I want to wish you all a happy Easter. This particular webinar is organized for purposes of and support of the upcoming ADR Week, Alternative Dispute Resolution Week, organized by the Judiciary of Tanzania under the High Court Mediation Centre Division. The week is scheduled to happen on the 13th up to the 17th of April 2026, and we expect that the Chief Justice of Tanzania will launch the ADR week on the 9th of April, this coming Wednesday. Sorry, this coming Thursday. Now, I will be projecting my slides and hopefully they do not interrupt us. The topic today is domain name disputes resolution for .tz. As I said, I am Madeline Kimei from iResolve Limited. We will know more about iResolve and its importance for domain name dispute resolution as we proceed on with this presentation. Now, the contents today, as you can see there, they're pretty much overview of the system and the system as we would learn. The topic is a very critical topic because domain names have become quite precious commodities for the internet. The internet has no boundaries. We understand there's no closing hour. It's unlike any other business. And so the trademarks that each domain holds is very unique, as that is the business function itself, assisted by the domain name that it holds. This means that it can often be put under pressure because the first to register a domain gets the lead and gets the right to register that domain. And as a result, a domain dispute can arise because of the many businesses that we see rising within different sectors. That require a name for them to be identified on the global web. And so our approach to domain names dispute cannot continue to be the same as any other dispute that we know of in the normal trade arenas, in the normal physical form arenas of business, or the businesses as we know altogether. Before the domain name space, of course, we knew that exclusive territory, would be a primary factor for trademarks, for example. There is no need to embrace or take ownership of, for example, a domain name disputes space in Africa, only to achieve this specifically for Tanzania. So there's an increased number of domains for .tz. So yes, there's an African-wide strategy to increase the number of domains, but also in country, as per the regulations and the legislations that have been put out since the awakening of the 2020 years, we've seen that there's more focus to build the volumes of .tz domain names in our registrations under the TCRA. And so most recently, we have seen a lot more growth in the space, as you can see in my next slide, where we see the statistics for .tz. And this is the most recent statistics, where you see that build up to about 10,900 from the year 2005 up to the year 2026. You can see that trajectory going up. And it's really the domain name registrants are becoming more and more aware that they have to become owners of these domains, these certain domains that they function. And so they're running off to register them through the TCRA portal, that is the Karibu portal, where they have a specific registry for registration for applications to be made. And so a domain name dispute is a conflict that arises when one or more than one individual or group believes that it owns or has registered a specific domain. And this is where it kicks off the whole journey to where a dispute might arise. And so you can see the numbers are growing, and inevitably we will be seeing more and more, or we are witnessing more domain name disputes in our country. And so now, understanding that there's growth, domain name disputes is quite a user-friendly form of a name to internet protocol address. So it's a protocol address. So specifically, you have your internet protocol address, which is for iResolve, www.iresolve.co.tz. And so this is specifically our unique address on the internet on the internet or IP platforms. And so gives us that visibility for viewers to visit our website and to learn more about us. So these addresses are to the internet web servers are signed and managed through a domain name system. This is now under the TCRA. That domain name system globally distributes internet databases, which are administered by the entity called ICANN, the Internet Corporation for Assigned Names and Numbers. And so a domain name identifies a website by that unique name, as I said, which is usually the brand name or the trademark, such as iResolve. So yes, we understand how these computers are connected to the internet, have unique numerical addresses, such as the one that I've just given you as an example, iresolve.co.tz. And so this now translates into this this unique name that one can maintain. So domain names are used to identify one or more IP address, as the slide tells you there. And there are concurrent rights. So registration is on a first come, first serve basis, as I've already presented, simply because you have a registered trade or service mark, have a registered company name, or have been using a trademark for a length of period where you can identify that this is you as a legitimate reason for you to register it as a domain. I'm not sure why the presentation keeps coming out, but I hope you can see the presentation in front of you. Try to share again. Okay. And so the domain name registration system is distinct, as we've come to learn. It trickles down from that global influence of the ICANN, and then the country level signs up for this particular system that is set up for the Internet Protocol addresses. There are different types of domain, as the slide indicates here. There's that global generic top-level domain, which are .biz, .com, .info, .name. We're aware of them. These are managed by ICANN, authorized by the ICANN at the top generic top level. And then there's the country code top level, which is, for example, as you can see, .co.uk, .france, .de, which is Germany. All these are managed by the individual country level. And then you see that I've indicated there in highlight that the TCRA is the registry for Tanzania ccTLD, which is the top level domain at the country code level. And so they manage the .co.tz, the go.tz, the or.tz, the school sc.tz, and so on and so forth. And so this is where we're going to be looking at in our presentation, this particular country code top level domain and how you manage disputes on that particular level. Then the GTLDs, of course, we've said already that the registry operates off the ICANN, as my last bullet says. Before we transition on to understanding the disputes itself, we spoke of, and you heard me talk about a trademark. So a domain name registrant does not obtain any legal right to use that particular domain name simply because he has registered the domain. He could still be liable for trademark infringement, as we understand defined trademark in our Trademark and Services Marks Act. There's a scope that is provided for in that definition. So the registration process renders that it has fewer formalities with the domain registration system than most trademark systems, and that's less inquiry into the validity of the registration for domain names. The domain names, once you've registered your domain, that particular registration, as smooth as it is, because you're basically just registering your website, that gives you fewer formalities as opposed to the trademark process that we are aware of that goes through the BRELA system. And so a domain registrant does not obtain any legal right to use that particular domain simply because he has registered the domain name. He could still be liable for trademark infringement. Why this is the case is that, somebody might have registered iResolve prior to me establishing a domain name called www.iresolve.co.tz. And so they would probably have the first come, first served sort of right to that particular entitlement, to that trademark, if they had registered prior to me registering my domain. So the distinction the distinction between a trademark and a domain is very relevant. It's very relevant for one to be able to connect with that domain name, but it's also material in fact that the scope of protection, that available right, is as well defined in our laws as you can see there. It says any sign capable of being represented graphically, which is capable of distinguishing goods or services of one undertaking from those other undertakings. So a trademark is protected by the laws of the country. We're fully aware under the Trademark and Services Marks Act, and that particular trademark may be any sign that is distinctive. So firstly, unlike a trademark, the concept of confusingly similar, we will come to learn, does not exist in domain names. Confusingly similar, it does not exist in domain names, as we'll come to learn. And then secondly, unlike domain names, the registration of the marks is subjected to a classification system, meaning it's identical trademark that are used to identify different products and services that can exist. That we're aware of because whenever we're registering for a trademark, there's that classification system that one has to drop onto for them to be able to satisfy the requirements to the trademark. And then on the other hand, since the internet allows for access without any geographical limitation, a domain name is potentially accessible irrespective of the geographical location of the consumer. And And so this is another distinct feature between the trademark system and the domain name system. And then, of course, the outcome of this potential sort of universal connectivity that we've just noted with regards to domains. And then my slide is dropping off again. I'm not sure what the problem is, but hopefully you're still seeing the presentation in front of you. The presentation in front of you. I hope you can see it. So I was talking about the universal connectivity. It's not only that a domain name would require worldwide exclusivity, but also that national laws might be inadequate to effectively protect that domain name. So there is that lacuna back then that was existing, necessitating international regulation of domain name systems. And that's how we resulted to having this ICANN system put up all together to be able to now allow parties to be that in any instance that one occurs that there's two or more parties claiming the right to the same domain, they have a recourse for their dispute. And so the importance of this domain dispute system, as you can see on my slide, it's pretty clear. It protects the brand identity. It protects and prevents cyber squatting, which is an issue that penetrates throughout the internet world. Promotes trust in digital spaces. I would not be able to trust the digital space if somebody else can project iResolve in a different way and receive income from it using the image that we already have created over the years, 14 years plus. And so, it's very important because it builds this trust and promotes trust for the digital space for businesses to grow competitively. And then it ensures fair use of domain names. And that fairness is what attracts people to being creative in developing their domains, as we would see in later slides. And then, of course, as a result of all these other four issues, it supports growth, digital economy growth, and exponentially, really, we've seen through the system, it enables that parties are able to register their domains and feel that they would not be involved in trademark infringement, bad faith registration, cyber squatting, misleading others, and misleading others into the domain use. And so having an administrative specialized procedure, and not the court system, mind you, has benefited this particular space, domain space, digital space, very much. And so now we move on in my presentation to now speak more specifically to the dispute resolution framework. And as I say, the dispute resolution framework starts off with the Internet Corporation for Assigned Names and Numbers, ICANN. This particular entity was established in 1998 with the purpose of ensuring that the unity and stability at international level is kept to at par and it kept in uniformity throughout the globe. And so it approved the dispute resolution service providers according to the UDRP, apologies, Uniform Domain Name Dispute Resolution Policy. So they put up this policy in 1999 for the resolution of disputes, and this was following a process of the World International Property Organization spearheading this formation of this particular registration for internet domain names dispute resolution. As a rule, of course, the registrars that had agreed upon the policy, the UDRP policy, had to incorporate it by reference with registration agreements for that domain, for those domain names. So Tanzania was party to this for the .coms, the .nets, the dots, and so on and so forth at the top level. Generic Tanzania is part and parcel of the system. And then, of course, having competent courts of law that would apply and have applicable law to these as structured under the TCRA regulations and legislations that speak to domain names. And so the UDRP mechanism for resolving disputes between domain names owners and trademark holders who claim that there's an infringement of their trademark has been set up, and it has a key advantage to the system by expediting these disputes through a uniform domain name dispute resolution policy, UDRP policy. And the UDRP policy, once it took place, the largest one that run these cases was the World International Property Organization Arbitration and Mediation Center, the WIPO Mediation Center, Arbitration and Mediation Center. And you can see here on my next slide where I project their latest statistics. Their latest statistics show that it has reached a very good number of domain name disputes cases, 6,200 to mention. Over the past 25 years of it operating, it has resolved 80,000 cases. And so the 6,200 are just for the 2025 year. And then throughout the years, 25 years, it has been able to resolve over 8,000 cases. I hope you're able to see my slide. And if you can see the slide, please do react using the actions, or you could write in the comments just to inform me that you can see the slides, because I wouldn't want to be talking without any video, without any slides, and it wouldn't be very appealing to most of us if that would be the case. Kemi, can you confirm by action if you can see that? It's fantastic. Thank you. And so the growth, for example, as we can see in the WIPO UDRP policies, sort of and country level cases, you can see that growth go up because businesses are becoming more and more sort of digitalized. They have much more space on the internet. And so therefore, there's more registrations of generic top level and country code level. So the split there is that they had 70,000 generic top level and then only 10,000 country code top level. So the country code top level are the .tz, .co, .ke for Kenya, and so on and so forth. So you can see they're getting a lot more cases for the generic as opposed to the country code. Why? Why? Because countries have implemented certain processes, certain alternatives, because the WIPO is very expensive. So to lodge a claim for a complaint for domain disputes at the WIPO could range from the $4,000 upwards. And so not a lot of businesses from a country level domain would be able to afford the panels and the administrative costs of the WIPO Arbitration and Mediation Center. And so countries have come up and formulated in-country level dispute resolution providers and have approved and accredited some. So for example, in Hong Kong, the HKIAC, which is the Hong Kong International Arbitration Center, is one of those approved centers for Hong Kong domains disputes. And then you can see their data there. They tell you they had 142 global ICANN uniform domain name disputes. Those are now the generic level ones, .com, .net, .org, .ai. And then in China alone, they had, which is the country code level. For them, of course, it's a bit, tricky with China and Hong Kong, but they had 38 from the Chinese domain dispute resolution policy. And then they had about just five for the Hong Kong domain name dispute resolution policy, which is the .hk, not as many as we would want them to be. But it's the case here as well in Tanzania. For example, for the year between the year 2022 to where I'm making this presentation, we've only had two complaints that have gone through the entire process that I'm going to be presenting today. And those cases are published on our website. One was with a company called Letta, and then the other was, if I can recall the name, it's on the website. There's another case as well. Letta ended up in a consent decision where they agreed to resolve mutually. They had a settlement agreement, and that settlement agreement was recorded as a decision by consent. And then there was another one which was ended in the transfer of the domain to the complainant. And that is also on our website, and I'll be able to share the link after the presentation. Now, for .tz, we have specifically laws that were enacted in 2020, 2020 and 2021, and in 2022 as well, updated, and which resulted to having an approved accredited dispute resolution player such as iResolve being onboarded. Prior to the 2020 year, the TCRA had a different unit called TZNIC. Tanzania National Information Center, I think it was called. We had an MOU with them, so from 2016, and they were using the UDRP policy because in country we had no this country level dispute resolution accreditation yet. But in 2020, when they resolved that they will have and introduce this particular service for country level codes, then they entered a different MOU with iResolve again in 2022, which implemented now the laws that are in front of you. Electronic and Postal Communication Domain Names Management Regulation, GN 940, 2020, which is read together with the recent amendment, which Honorable Judge Makaramba earlier this morning shared with me. Otherwise, it might have, slipped my tongue, and I might have not updated you as much as I would have wished you to understand. So the amendment doesn't have a lot of weight, but it does include, the registration mode and the management fees, and there's a schedule that was amended in 2023. So you might have to also look at that. And then they have these guidelines, and the TCRA guidelines are very helpful, usually very helpful for one to be able to understand the dispute resolution process as per the 2021 guidelines, and in complement of those regulations which came in 2020. And so the key components of the .tz-DRP policies is that we apply the country code domain, which is the .co.tz, .or.tz, and the rest. It's an administrative process, and so it is administered by iResolve, for example, as one of those accredited institutions. If it was TAB, Tanzania Institute for Arbitrators, then they would also have their own supplementary rules to the GNs. But now I'm speaking only about the iResolve supplementary rules, and we play administrative parts in ensuring that the dispute resolution process is adhering to the domain, to the rules of the game, basically. And then you use appointed neutrals, and these neutrals include practitioners. It includes persons who are conversant with domain spaces, and so you don't have to be a legal background holder, profession. It can be from different spaces, and we've had panelists which span out from lawyers themselves. And so the decisions must be complied to, and the decisions which are rendered by these panelists must comply to the Tanzanian regulations and the guidelines that we have noted that were issued in 2021. Now, if we look at the Domain Names Management Regulation 2020, this regulates the use of domains. If we look at Regulation 2 specifically, it tells you domain name is a unique name that identifies internet resources, such as the websites that is registered as a second level or a third level domain. And so it gives you an understanding, a very good grip of what we mean by domain for .tz. Regulation 3, subsection 1 makes it a requirement that we use .tz for our businesses. If you've got a registered business in Tanzania, it necessitates, that makes it a necessity that you have a registered domain name that uses .tz. And this is one of those ambitions countrywide, many countries have had, to grow the pool of domains that are registered within the countries. It gives it a really good picture that businesses are thriving on the internet, the digital space is growing, and it shows you that track record in real time when people register for their domains with the TCRA. So the regulation also caters for the disputes between the domain name holders and third parties, and how those are to be handled. And then it directs you to the guidelines as well, for you to be able to use them in complement. Through these regulations, then we were accredited, as I said, initially in 2016, and then we were renewed in 2022 after the new amendments to the regulations. And so as a DR or dispute resolution provider, we can handle the disputes. And by those regulations, which we've just had a look at, just as an overview, we then had to create supplemental rules that would basically go hand in hand with how we would manage the process as administrators. And these supplemental rules had to be read together with the regulation and also the guidelines that TCRA had already started drafting. We had a little say, of course, on the guidelines because then we needed to be able to set a process that spoke to them. And so we did have some input through that lobbying initially before they were issued. And so as a provider, we provide efficient dispute resolution services to the .tz registrants. There is an appellate mechanism also triggered under the Regulation 24, subsection 4, where they tell you that the last resort or seeking redress for any sort of appeal is through the court. Initially, first to the FCT, which is the Fair Competition Tribunal, and then the last appellate space that parties might have if they're still aggrieved is the courts of law. Now, by now we probably understand why the regulators had to put this in place, because the procedure would be otherwise very expensive. This procedure is less expensive than litigation, trust me. These decisions can be made more quickly, more cheaply than the judicial decisions that one would probably think are quicker, but no, not at all. Jurisdictional problems are also minimized by having this kind of system. The adjudicators or arbitrators, we would call them, are automatically sort of have jurisdiction over the disputes once they have been given this mandate and been empaneled by the parties. And so it's very clear and simple procedural rules if once we start having a look at them in toothpick wise, and they relate and provide for appropriate language for the proceedings to be much more friendly, user friendly. Then, of course, the implementation is on a stare decisis. They do not or does not implement a policy of stare decisis, where we rely on precedent, not at all. So that's also gone away with, and the adjudicators are much more at ease to be persuaded and to provide and decisions which are strictly within the circumstances at hand, facts and evidence that's before them. The documents only procedure is adopted usually. The two cases, for example, that we've had at iResolve over the current period, all these cases were document only. There was no physical hearing conducted in any of these cases. And so that shows you that really this process is much more expedited. And even in the WIPO experience, I've noted that most of the cases reported by the WIPO are done by documents only basis. And this saves time. It's much more, and it gives the claimant or the complainant that sort of advantage of ensuring that they have put out all their evidence at the first round of filing their complaint. And so that it also gives it less of a back and forth sort of rejoinders and replies, which are not necessary in this particular process. Not necessary, but provided for in the rules. So then there's the temporary prevention of the registrants from transferring a domain to a third party until a decision has been made. So if I hold this domain that a complaint has been filed to, I can't transfer it until that decision is made. And you would learn later how that decision is communicated to TCRA by iResolve. And only when TCRA receives the decision from iResolve is when TCRA then acts with its mandate and power under the regulations and the Act, the IPOCA, to proceed to transfer or assign back to the person that has won that particular domain. Now, the disadvantages, of course, as we can see them there, I won't go into them in detail, but it could be too expensive. It's still, if it goes to the WIPO, if you've got a country level domain dispute and you go to the WIPO, it's too expensive. And persons there they've got a better pool of persons with expertise. And so the disadvantage in Tanzania would be that we don't have a big pool of persons who are knowledgeable about the procedure. And that's why this webinar today. Limited, of course, to protecting the trademark interests and the domain name space, as provided for in the UDRP, if you do a generic country level sort of dispute, limited to these two, GTLD and ccTLDs, lack of statistics, as I said, so the panelists are not bound to follow previous decisions and can be uncertain and inconsistent, as you can see there in my notes. The decisions using UDRP are also not binding on the courts, and proceedings have to be initiated after the panel has given its judgment, especially if you received a judgment that you want to, the other part is opposing and doesn't want to implement in good faith or in cooperation. And then the proceedings or decisions cannot be kept confidential. As I said, everything is published on our website. The two cases that we've had, I wish there were more, they're published. If there were more, then you will all be very happy people so that you could read how decisions are made with regards to ccTLD for .tz. And then, of course, protection of the IPR or the intellectual property is weak and the enforcement capacity is too diffused and scattered. What I meant there was that, in the past, and this comment is a little bit, a little bit old or ancient, because we have improved, the systems have improved, the courts have improved in implementing and enforcing intellectual property in our country. Now, let's move away from the disadvantages. And since we have about 20 minutes left of our, I think less than 20 minutes left, I'll move on to the types of cases that we have been seeing. So the third party, the person who's complaining, comes in purposefully chosen a domain name, and that it has he says that is confusingly similar to a trademark clearly belonging to another party. It is not clear that the domain owner registered a particular name or mark to trade off, or a trademark owner's goodwill. So these are arguments that one can make. A cyber squatting issue where someone registers a domain name in bad faith, which is usually an intention to profit from the trademark belonging to that somebody else. So somebody passing off as iResolve and then rendering the services. This is 91% of the cases as of 2012. Sorry, the data is backdated. But even if you check today for 2025 cases, the cyber squatting issue is a primary concern. 91% of the cases are usually cyber squatting. Even the case that you will see there for the travel agent case that is on iResolve, that one was cyber squatting. He was getting, bookings for the tourism over using Easy Travel while they were actually not Easy Travel. The brand names, the generic names, the geographical, cultural issues also that intersect the internet also come up. And so the common disputes, cyber squatting, this is really a key one for the space. Now, so you've identified the kind of dispute that you have. How then do you come to iResolve? Well, first, before you come to iResolve, you would be able to send us an email. If you don't have the supplemental rules, we'll share with you the supplemental rules dated 2022 so that you can understand the process. The rules are the ones that set the process. The rules are read together, as I said earlier, with the Electronic Postal Communications domain names management regulations and the domain names dispute resolution guidelines, which guide us. Of course, these rules can be amended by us when we see that they probably are maybe cumbersome, or the parties have given us feedback to ensure that they are user-friendly. We would implement amendments, and these amendments are usually have to be approved also by the TCRA. who we have an MOU with. The current version has complaint submission. It governs the complaint submissions and the response, and if there's any reply, the timelines, and everything that is with regards to the complaint submission is provided for in these rules. There is a no liability for clause for iResolve and its panelists, unless, of course, the wrongdoing was done deliberately, and so on and so forth, and that the parties indemnify iResolve for using for issues arising from electronic processing. So we do have an indemnity clause within the rules themselves, and we're kept indemnified on that basis, and the rules are clear. So the key features of the complaint form, for example, it has an area where you would stipulate the domain name itself. You would stipulate maybe the registrar or the registrant, their contacts, and then have specifically provide for the type of dispute. Remember, we spoke about these types, and they could be much lengthier than this. These are just examples, 6 examples that I've put out for you. But then you would specify why you're complaining, how you came about it, and you'd have a good understanding of the case put out in your complaint form number 1. And then we have a response. Because once we receive the complaint as iResolve, as administrators, we have to communicate the response to the respondent. The respondent then has 20 days to from the commencement to file in their response in a similar form called form number 2, which is the response. If there is any extensions of time on exceptional cases only, we would probably as administrators, be charged with ensuring that the party puts out a good case as to why they need an extension to file within the periods that are already set in the rules. And as administrators, we will then spearhead that by making the necessary decisions. Also, because of the fact that this process is very flexible and we want it to be less costly, there are also time limits and also response limits. For example, 20 pages or 5,000 words in response. So we don't want lengthy submissions by counsels to confuse the panelists. No. Just straight to the point, arguing your case, putting in the case law, if you're supporting with any previous decisions and so on and so forth, although they might not very much sway the decision maker, but still persuasive so that you get the result for your party. If there's going to be additional submissions, there's usually one additional submission round, which is 5 days from the response date by the complainant, and then the opposing party can also have another 5 days for a reply. And this is the process cannot be amended. The process itself doesn't allow for one to amend this complaint or response. Otherwise, it will be an everlasting process if these were allowed. And so the registrant of the domain name, would be there'll be a complainant, there'll be a respondent, there'll be the registrars, the dispute resolution provider, which is ourselves, iResolve, and then the administrative panel will be resulting end of this process, which is the person that will then come in to resolve the dispute under the dispute resolution provider's ambits. The complaint form, as I said earlier, it's very straightforward. A complainant must evaluate whether it's a case of cyber squatting, for example, and then translate it to, translate it into this complaint form. If it's a cyber squatting, then it requires that a complainant proves that there's a lack of legitimate use or bad faith registration and the use of that domain name. And so the first step really for complainants, you should always collect the evidence of that prior right and the domain owner's behavior or factors that can be relevant for that case for proving maybe cyber squatting, such as offers to sell, competitive website contents. All these factors are very important to put out. So identical or confusing, that's your first issue. no legitimate interest, so you have to prove this, use in bad faith, so you have to prove. So I've sort of trickled down what usually comes about in these complaint forms. So similarity is considered, visual and verbal comparison. So if the websites are really similar, there's only maybe an E falling out of easy, you know, and then no consideration of the products or services that are being put out there. Then there's no legitimate interest. This is another wing to it, and we'll look at them in greater detail in my next slides. But you must prove this to be present in your form by putting in evidence to show. The burden of proof is on the domain holder to show otherwise. And there's no exhaustive list here. Evidence can be tabled to the extent that you have collected in terms of your prior investigation and prior collection of evidence as a complainant. And then being used in bad faith. Maybe somebody's trying to resell it to a competitor. They've registered iResolve just for purposes of, just watching it for a while. iResolve has become very famous. They don't have a domain. Let me register it and hold it. And then the day I come and need iResolve, they come in and say, hey, you know what, I can resell it to you, because you need it so much, because this is your brand. And this happens a lot in our market space, where people are just fishing out for potential domains that might come in handy in the future. We saw that in the case of the Agricultural Bank in Tanzania, the TBDA, I think it's called. They had, somebody had registered something similar before them registering for their website, and they came in I think sometime in 2018, 2017, I think that's when they were just kicking up their services in the agricultural banking sector, and they needed a specific website, and then they found out that this website had already been registered by these cyber squatters. And so the grounds for disputing, as we said, similarities, intention to use of in bad faith, use of domain in misleading or harmful way. And then, of course, there's that fourth element, which is in our 2020 regulations, which is non-compliance to these regulations that have been put up by TCRA. Now, the standard of proof, as I said earlier, similar to the UDRP policy, which is designed to be fast and cost effective, the evidentiary burden mainly is on the complainant who is bringing the case against the other party, needs to prove that standard of it needs to reach that standard of proof, the general standard of proof, which is on a balance of probabilities or preponderance of the evidence standard, as we lawyers would know it. Some of you might be lawyers who are present here today. And so a respondent is now obliged to participate in that UDRP proceeding, and a default does not result in an automatic determination in complainant's favor. But if a respondent fails to reply, asserted facts may be taken as true and reasonable inferences drawn from information provided by the complainant. So that's what usually would result. In our setting, for example, respondents usually say, they can't do anything about it, and they keep quiet. And then at the end, the domain name dispute resolution provider has already assigned it to a panel. The panel would have to make a decision, and they would make a decision on the evidence that's before them. If it's only presented by the complainant, then they will draw the inferences as indicated on my slide. So the asserting party, the complainant, would typically need to establish that it is more likely than not that the claimed facts in his complaint are actually true. And that's very important, because that's where your complaint form comes in very handy, and making sure that you put it in when you're filing it in a very clear way. Now, these decisions are generally based on a commercial consideration that resemble the key features of the trademark infringement, as I said earlier in my presentation, and dilution of the actions between the parties, or dilution of them throughout the process of when they claim that particular domain had been or was now infringed. And so for the criteria that we use, which is similar to the UDRP criteria, the three-part rule, or the three-part criteria to prove a complaint being filed. We use that. The domain must be identical or confusingly similar, as stipulated in my previous slide. And then the registrant has no right or legitimate interest in that domain. And then the last part of the test is that the registrant registered and used the domain in bad faith. So these conditions, have been detailed in the policy and also have been detailed in our rules, which is the Supplemental Rules 2022 for iResolve. And the burden now, as I said earlier, is on the complainant to make sure that they have proved them to be true. So the first UDRP element requires evidence of the trademark. The UDRP sets the requirement of having those rights for the complainant to have standing to file the complaint. This is one of those standings that you have evidence of a trademark or service mark right, and so that's your first leg. And as you're aware, whereas a pending trademark application would usually not establish any trademark right under the UDRP, you would not have to then a good standing if you would not be able to show such right at the very stage of filing your complaint. I hope my slide is back up. So for the policy to recognize unregistered or common law trademarks, for example, it does recognize these two. However, in order for you to establish, as we all understand, that for the purposes of now the policy and also the supplemental rules under iResolve, a complainant must then establish a series of those factors which regard them as a complainant to have acquired this, this distinctive mark, all those marks that it complains of. So the easiest and of course the safest way for you to be able to establish rights as well as prove that the respondent is acting in bad faith is by registering the domain that is being disputed under the under the policy or under our country level policy, which is the GN for the GN 422 as it's been amended, that you've registered the right well in advance. So these are very critical factors, and that's why it's very important for one to maintain their websites and upkeep their websites, ensuring that they have and hold this right of trade. So the legitimate interest element is quite interesting because before any notice to the registrant of the dispute, the registrant had used or made demonstrable preparations to use the domain name or a name corresponding with the domain name in connection with the bona fide offering of a goods or services. So this is your legitimate interest, that you had that intent and you demonstrate that preparation to use that particular domain. So for example, if they had registered it before and I was already using iResolve, but somebody in the middle of me using iResolve, I haven't registered it, I'm offering my services in good faith, bona fide services, and then somebody registers it knowing that fully well Madeline will need this, then I might have that legitimate interest in this domain to prove the other was acting in bad faith. The registrant has been commonly known by the domain name, even if she had acquired no trademark or service mark rights in the name. The registrant is making legitimate non-commercial or fair use of the domain name without intent for commercial gain or to mislead, divert customers, or to tarnish the trademark or service mark at issue. So these are your legitimate interests, and these have to be proved for you to be this third limb of legitimate use is becoming, of course, it has to be proved, and it's becoming increasingly difficult, I must say, to establish it, and especially in this new age where many domain registrants utilize some form of online advertising. So it's very difficult to prove nowadays. And of course, the bad faith factors we've already noted in my previous slide, and these bad faith factors relate more closely to cyber squatting, I would say. So diverting users to other sites, if the registrant has multiple domains registered, and all these factors, very difficult to trace sometimes, but to trace bad faith sometimes, but it is doable, especially if you're able to see somebody is offering the domain on an auction site, for example. That can be construed as bad faith. But also it might go the other way around as well. So you need to be very careful on how you're tabling the particular case. I've got 5 minutes of this particular presentation. I hope I'll be able to take questions. A case law also shared to me earlier this morning by one honorable retired Judge Makaramba. If we know him, he has an interest in dispute resolution very much. And he shared this court case, which really speaks volumes as to how even our courts in common law jurisdictions have taken this protection of this domain name. It's an intellectual property, and it has been observed to be an intellectual property. And if the mark or the domain name has a complaint that someone is similar or confusingly similar in terms of possibly deceiving others or potential consumers, then this marks it very much as passing off under trademark law. This is what this case says. This is Satyam Infoway Limited. And there's many cases of this similar sort that can be digested by you in another time. What remedies are available? The remedies available, decisions, of course, under the rules, supplemental rules, 2 months. 2 months is a long time. UDRP provide for 2 months. Within 2 months, institution of proceedings. Our rules provide for a shorter time, 30 days. For a decision to have been communicated to the parties. And the remedies that the panelists can give are transfer of the domain name. I don't know how to increase the time here. I hope the time will increase by itself. But if we do drop off, then the rest of the presentation will be recorded. Please do look for a link for it afterwards if we do drop off, because I've got a couple of slides to go. The transfer of a domain name to the complaint, cancellation of the domain name, there's usually no compensation granted, so no money is involved or exchanged. And then there's no appellate mechanism within the UDRP policy itself. It's usually out of the policy itself. And with regards to the adjudicators that I've been speaking about, the panel of mediators, it would usually either be a single member or a 3-member panel. We've not seen a 3-member panel before at iResolve, although we do provide for it. But it can be picked by the parties. If you find that your dispute is very complex, then you choose a 3-member panel. Other than that, if there's more than one domain being disputed, also sometimes one can opt for a 3-member panel. But also the 3-member panel via the single-member panel has an impact on the fees that you pay to us as administrators, and also the fee that you pay to the members of the panel. The members, once selected, have to declare their independence and impartiality. There's a specific form that we've provided for in the supplemental rules. If one is to be disqualified, it's usually based on bias or personal knowledge of that particular domain or the parties involved. Maybe they've prior representation in other forums or financial interest in that domain, or there's a link between those parties involved, their counsels or their other representatives. And the challenges have to be filed to the iResolve administrative team within 5 days, and that's straight into our info@iresolve.co.tz email, and then we align it to somebody who internally will then look at the case and resolve as to whether there's a bias or not of that particular panel. The panels, once they've been, constituted, they are vested with power to rule on their own jurisdiction. They are vested with procedural issues under the guidelines and under the iResolve Supplemental Rules 2022. And so they can be able to tweak the rules to fit the best part of their cases, the circumstances of the cases. The challenges, of course, as I said, are resolved by the administrative team. And then the decisions can be corrected. The decisions, once rendered by the panel, it's not final up until the 3 days where they have a right to either the parties can request for the correction, or the panel themselves within 7 days can request or correct any errors that they see, typographical ones, in terms of the decision that they have rendered. Once the decision has been done, we, as iResolve, send it off to the registrars, and we send it to the TCRA within 3 days of its finality. And then once the decision has been received by TCRA does their part in their mandate to make sure that if it's a transfer, they transfer it. If it's not a transfer, then they keep it as it is. If it's deletion, then it's a deletion, and so on and so forth. And so that for it gets to be implemented by TCRA. If there's a challenge, of course, then the challenges are done through the process that is going to be on the next slide. The decisions for us as administrators or dispute resolution providers, we then have to publish them. This is a rule. This is a regulation. It must be published for transparency purposes. Enforcement-wise, as I said, this is very interesting because we do have appellate provisions under Regulation 23, subsection 4, where we have the Fair Competition Tribunal, and then the other option, of course, the last resort, which is the Court of Law, to challenge that decision under Regulation 24, subsection 4. International-wise, enforcement, as we noted earlier, it's pretty much a very difficult to challenge these decisions. Registrars are obliged to take the necessary steps to enforce the dispute resolution domain name transfer decisions. So the registrars for this example is TCRA. So subject to the losing parties maybe filing that proceeding in court or the FCT, TCRA is duty bound to do the steps that have been decided by the tribunal. By the panel. Then the schedule of fees are very straightforward. The rules have a schedule, and in the schedules of the supplemental rules for .tz under iResolve, these are the fees. You can see there that if it's more than one, if it's 1 to 2 domain names, then the single member would have to be paid 1.5. 3-member panel would have to be paid 3 million. And then the administrative fee for iResolve would be 1.4. So this is very much the fees that we, through very many consultative meetings with TCRA, we found to be very, very probably would be well accepted by the public, considering that the WIPO, the calculations at the WIPO are much higher in dollars, and they do kick off at $2,500 for one domain name, one single panel, administrative fee only. And then you, on top of the $2,500, which has now probably increased to $4,500, there's now also the fee for the member of the panel. Or 3 members of the panel, which is added on top. So the calculations, as we had consulted with TCRA, were based on the domain name settlements requested, the number of parties involved, how the total amount is divided between iResolve administrative fee and the payments to the panelists. So all this is reflected to this particular table that you see here. And that comes to an end of the end of my presentation with respect to the .tz process for domain name dispute resolution under the supplemental rules for .tz at iResolve. I thank you for your ears. I thank you for listening. I do have a couple of slides if you want to remain behind with regards to cases that are very interesting. Of course, these are cases that are just examples of how they usually end up in terms of decision making. As you can see here, the KFC, for example, we all know of Kentucky Fried Chicken. We all love KFC. There was a case in Korea where the complainant opened its first KFC restaurant in Korea in 1984. This is KFC from the United States. And in 2002, they had 236 KFC restaurants. So in 2002, the complainant, who was KFC, nearly 200 KFC trademark registered in 99 jurisdictions, including the Republic of Korea and Romania. So the conclusion here, because of course the panelist Jonas goes on to say the domain name kfc.ro is identical with the trademark KFC. So KFC's complaint, is like saying, yes, those kfc.ro Romania is very identical to our brand KFC. And then the respondent has no rights or legitimate interest in the domain name. Whoever had the .co.ro, kfc.ro, had no right or legitimate interest. That's what the panelist held. And then he also then goes on to say on the third leg, the domain name has been registered and is being used in bad faith by the respondent. So the domain name was transferred back to the complainant, which was KFC, and its many, many restaurants that he had just opened in those jurisdictions, including Korea. And so you can see how then these come up into conclusion of a decision to transfer. The same here with Christian Dior. Dior complained that the domain name was being used as a website for adults, maybe an adult website, prohibiting people from the age of under 18. I won't go into the facts, but the conclusions there, what the panelists held was that the similarity which was leading to confusion between domain name and the complainant's trademark, which was Christian Dior, and then the nature of the website, which was, pornographic website, was slanderous and really a defamation to that trademark. So the concept of tarnishment of the trademark was also partly part of this case, determining this case. And then the respondent on the third leg, the panelists held, had intentionally targeted by registering that domain where sufficient arguments for the panel to retain the respondent's bad faith at the registration and use of the domain. So, the argument here that there was sufficient evidence that this was a bad faith move by the respondent. And so the transfer was back to the complainant, who was Christian Dior in that case. So yes, thank you very much. And I hope you enjoyed the presentation. I took up 70 minutes of your time and hope that you were able to pick in where you came in, and I would leave you at this instance to, if you have any questions, the Q&A box is open. I think we've been given the extension of time by Microsoft Teams, and so if you have any questions, you can put your mic to ask a question, or we can receive the question on the Q&A. Thank you very much for your attention, and I wish you all a wonderful, wonderful week ahead. And I hope to see you all for the ADR week, which commences on the 13th of April, 2026, and will end on the 17th of April, 2026. This week marks a remarkable week, being that it is championed and spearheaded by the Judiciary of Tanzania, and it shows the importance of alternative dispute resolution in our country as a legitimate process or mechanisms that should be embraced and continue to be applied in our day-to-day business, in the space of domain names, and in many other spaces within our communities. So I thank you. I do not see any hand up, and I do not see any questions. And so therefore, I would let you enjoy the rest of your Easter Monday. Thank you very much for listening.